When the trust sues the beneficiary to collect a debt, does the beneficiary get to see the trust lawyer's confidential litigation strategy and communications with the trustee in the very litigation against the beneficiary? The Pennsylvania Superior Court faced this matter of first impression in the Hempt case. Regarding trust administration, a beneficiary can generally see what the trustee discussed with trust lawyers. That's the fiduciary exception to the attorney-client privilege. But it has limits. When a beneficiary sues the trustee keeps attorney-client privilege over his defense, a defensive exception to the fiduciary exception. That's settled law in Pennsylvania and other states. Hempt answers the inverse. Is there an offensive adversary exemption when the trustee sues the beneficiary on behalf of the trust? Join us to see how it litigated. I'm Kelly Lise Murray, and this is Wealth Litigated, briefly, delivering all the drama of true crime without the blood. We break down actual court cases that impact your professional practice and your clients' wealth outcomes. Let's gavel in. What happens when the beneficiary nephew refuses to reimburse the QTIP Trust for $1 million in taxes prepaid on his behalf? In a word, litigation. But that's just the half of it. In a unique twist, the beneficiary nephew weaponizes discovery and demanded trustees' confidential communications with trust litigation counsel. In the Hempt case, the Pennsylvania Appellate Court answers this question: whether the fiduciary exception overrides attorney-client privilege even in trustee versus beneficiary adversary proceedings. The stakeholders are related. Mr. Max is the settlor of the QTIP Trust. His wife is the lifetime income beneficiary. Mr. Max passes away first. Then one of the two adult sons passes away. Then Ms. Martha. The trustee of the QTIP Trust is the other adult son. He's also a beneficiary of this trust and the co-administrator of the estate of Mr. Max's sister, Miss Jean. The underlying litigation filed by the trustee concerns repayment of prepaid taxes, but the counterclaim filed by the beneficiary nephew brings in trust administration issues and also co-administration issues with Miss Jean's estate. The QTIP Trust was created in 1987, and that trust instrument required beneficiaries to pay taxes on distributions they receive. The QTIP Trust was funded with stock from the family business. After Ms. Martha passed away, and shares were being distributed to beneficiaries, the trustee uncle and the beneficiary nephew signed the 2017 Receipt, Release, and Indemnification Agreement. It had two core provisions. First, that the beneficiary acknowledged he would pay his portion of taxes on the family business shares distributed to him from the QTIP Trust. Second, the beneficiary acknowledged he would indemnify the trustee uncle individually and in his capacity as trustee for any taxes the trust paid, which raises the question, why does the trustee need to be indemnified for prepaying taxes on behalf of the beneficiary nephew? That's explained by the 1987 QTIP Trust instrument. The QTIP Trust required beneficiaries to pay their own taxes. The trustee wanted to value the corporate stock, quantify the taxes, and have the taxes paid before stock was distributed. The beneficiary nephew objected to that timeline. Given that dispute, they signed the 2017 agreement. The Hempt Appellate Court decision gives us some insight into the family dynamics. And before I read this quote, I want to define some of the terms the court uses. The beneficiary nephew is described as the objector. That would be his role in the litigation. The trustee uncle suing the beneficiary to recoup the $1 million in taxes. The appellate court describes that as the civil action. And the indemnification agreement is described as the 2017 agreement. Quote, critically, the adversarial relationship between trustee and objector predates the civil action and indeed was the genesis of the 2017 agreement that trustee initiated the civil action to enforce. The Hempt timeline. As a recap, the QTIP Trust was created in 1987. Then something happens in 2012. We wouldn't even know about it if the beneficiary nephew didn't file a counterclaim against his trustee uncle personally. Apparently in 2012, there was distributions from the QTIP Trust during Miss Martha's lifetime, where the trustee uncle received stock from the family business. And according to the beneficiary nephew, the reason for the distribution of this stock during Miss Martha's lifetime was to avoid having to personally pay taxes, meaning the trustee uncle received this stock during his mother's lifetime to avoid owing taxes. That's argued by the beneficiary nephew. In 2016, Ms. Martha passes away, and the trustee delays distributing the family business stock. Beneficiary nephew objects to that delay, objects to paying tax personally before receiving the stock. That leads to the 2017 reimbursement and indemnification agreement. When the beneficiary nephew refuses to reimburse the trust in December of 2021, the trustee uncle sues, and that's the civil litigation. In 2022, the beneficiary nephew counterclaims against the trustee. And then in 2024, the discovery dispute is what goes up on appeal. It's an interlocutory appeal, meaning it's an appeal from a non-final order, an order that doesn't resolve the entire litigation. This discovery dispute doesn't resolve any of the substantive arguments. In discovery, the beneficiary nephew and his lawyers demanded that the trustee and his lawyers disclose what would normally be attorney-client and work product privileged information. The trustee objected, and the trial court ruled in favor of the beneficiary nephew. Because the disclosure of what is claimed to be attorney-client privilege cannot be undone, this appeal couldn't wait for the resolution of the entire case, and that's why the Hempt interlocutory appeal is accepted and resolved at the intermediate appellate level in 2025. And if you look at the timeline, it's 4 years between the filing of the civil action and appellate resolution of the discovery dispute. The counterclaims by the beneficiary nephew demanded an accounting, potential removal of the trustee uncle, citing that 2012 distribution. The trial court relied on Pennsylvania precedent like SCAFE. And something else to point out here is there is no Pennsylvania case law supporting the trustee uncle's position that there should be an exemption from the fiduciary exception to attorney-client privilege and work product doctrine when a trust is suing a beneficiary. Because this is an issue of first impression, it makes complete sense that the trial court, based on available precedent, ruled in favor of the beneficiary nephew. Something else to point out from the trial level decision about the discovery dispute, the only items that remained privileged from disclosure were defensive, meaning this counterclaim against the uncle personally and for his management of the trust as trustee. Those are considered defensive, and the fiduciary exception does not apply. Because that is already resolved in Pennsylvania, that is what the trial court permitted the trustee uncle to withhold from the beneficiary nephew. But the offensive litigation, the trust lawsuit against the beneficiary nephew at the trial level, all of the offensive attorney-client privileged information would have been disclosed under the trial court's order, and that's what the appellate court had to resolve. Attorney-client privilege and work product doctrine as a privilege. There's a fiduciary exception, and that's a common law rule that the trustee is managing trust assets on behalf of the beneficiaries, that the beneficiaries have standing to request an accounting and have standing to receive information and trust documents concerning the management of trust administration. The fiduciary exception to attorney-client privilege permits disclosure when a beneficiary requests it of attorney-client communications between the trustee on behalf of the trust and trust counsel, particularly in third-party litigation. As the appellant on appeal, the trustee uncle was asking for a new exemption. It's an issue of first impression in Pennsylvania as of 2025. On appeal, the trial court's ruling is affirmed in part, vacated in part, and remanded. Vacated because the court adopts the adversary exemption. The remainder is affirmed, and that's the general trust and estate administration documents. Those had to be disclosed. On remand, everything being withheld had to be included in a privilege log: source, data obtained, related litigation, date of payment of legal fees, the account, and the amount. because they were also arguing who's paying the legal fees. Is the trust paying on behalf of the personal defense of the trustee? All of that had to be detailed in privilege logs. So why did the trial court rule in favor of the beneficiary nephew, and why did the appellate court rule in favor of the trustee uncle? Mainly because of Pennsylvania precedent. There's a 1974 Pennsylvania Supreme Court case, Rosenblum, confirming the fiduciary exception to attorney-client privilege, expounding on the beneficiary's right to inspect the trust administration documents, which includes consultation with legal counsel on behalf of the trust. Then in 2021, McAleer case, the Pennsylvania Supreme Court held that the trustee did not preserve his attorney-client privilege claim at the trial level, and the Pennsylvania Supreme Court ruled all of that information had to be disclosed to those beneficiaries. Scaife is an intermediate appellate decision in Pennsylvania from 2022, and this is what the trial court in Hempt based its ruling on. Scaife was a beneficiary's estate suing the trust and the trustee for failure to create a second trust during that beneficiary's lifetime. That was the underlying dispute. The estate demanded in discovery communications between the trustee and trust counsel concerning the decision not to create a second trust. All of that information was required to be produced as part of the fiduciary exception to the attorney-client and work product privileges. Based on Scaife, the Hempt trial court ruled in favor of the beneficiary nephew. We already know the result on appeal in Hempt. Here's some additional insight. The fiduciary exception already did not apply to a trustee's defensive litigation communications with counsel. If the trustee is personally being sued, the Hempt decision adds an offensive component. When the trustee sues a beneficiary on behalf of the trust, that is what is also excluded from the fiduciary exception and remains attorney-client privilege. Put a post-it on this. The Hempt case gives us specific takeaways about structuring the relationship between a trust, the trustee, and outside legal counsel to preserve attorney-client and work product privileges, especially when a beneficiary invokes the fiduciary exception. Consider segmented legal billing from the outset. When the trust is the litigant, privilege logs and segmented legal work for trust administration that would be discoverable by beneficiaries under the fiduciary exception. Second, the trustee's personal liability that is defensive and that is already outside of the fiduciary exception that has remained privileged. 3 is the trustee on behalf of the trust suing a beneficiary. This is the Hempt result. Hempt gives us the new adversary exemption to the fiduciary exception to attorney-client and work product privilege. What the trustee uncle was able to withhold from the beneficiary nephew included communications and documents regarding strategy, positions, opinions of counsel, analysis of strengths and weaknesses of the litigation between the trust and the beneficiary nephew to recoup that $1 million in prepaid taxes. And then the Scaife distinction. Scaife was precedent that the Hempt trial court relied on. Under Scaife, did the dispute originate within the trust administration or external to it? Did the litigation arise before the trust accounting? Those are the facts of Hempt. Here's another question raised by the Hempt result. Could the trustee uncle have avoided litigation? Mechanically, it looks like he tried. That seems to be the purpose of that 2017 reimbursement and indemnification agreement. What if the trustee didn't negotiate and sign that 2017 agreement and instead withheld disbursements? The beneficiary nephew could have sued about that. So the first lawsuit instead could have been what turned out to become the counterclaim. The bottom line, it looks like the trustee was faced with not litigation versus no litigation, but instead which lawsuit in which court on which timeline. When you pull files this week, consider the family dynamics, particularly when the stakeholders are all related, where the trustee is related to the beneficiaries, and whether those family dynamics include disputes that predate trust disbursements and overall trust administration. When advising clients whether trust communications with outside counsel are privileged from beneficiaries, maybe is not wealth protection, and it may become wealth litigated. Thank you for joining us.
This is Wealth Litigated, where the real courtroom battles we analyze today are your roadmap to stronger asset protection and better wealth outcomes. Follow us on your favorite podcast platform or subscribe on YouTube so you never miss a weekly episode. Questions or cases? Visit wealthlitigated.com/questions. This show is for informational and educational purposes only and does not constitute legal, tax, or financial advice. No attorney-client relationship is formed. Consult a qualified professional for advice specific to your situation and jurisdiction. Wealth Litigated is now adjourned.